Hello, everyone, and welcome to another episode of They Don't Teach This in Law School. We have two guests today. I think it's the first time we've ever had two guests on the show, so I'm excited for the crossover talk. It feels apropos to have these two gentlemen here for a first-time two-guest cross-talk. We'll be all over it type of episode. Two friends of mine, two guys who I really respect in the digital marketing space of Legal Phoenix, Ron Latz. Ron, welcome to the show. Great to have you back.
Thanks, Charley.
And
appreciate it.
From Attorney Sync, Gyi Tsakalakis.
Wow. I am humbled and impressed and grateful. Thank you, Charlie, man. That really well done there.
Did I get it right?
Very, very technically, there's Ariadis at the beginning, but
okay.
Otherwise, beautiful. I think any Greek speaker would be very impressed. You said my name better than many of my family members say it, so great job.
Well, Gyi, it's great to have you as well. So, Ron, we're going to start with you answering the question, what's the one thing they don't teach you in law school?
All right. Well, one thing they don't teach you in law school is how to protect your data, manage information systems, and also ensure that you have ownership and administrative rights and access to all the tools and systems and platforms that most law firms rely heavily upon in order to grow their firms and ensure that marketing is successful and that they can dot I's and cross their T's.
Even though that was a relatively smooth and calm delivery, I could definitely hear the deep-seated anger that lived underneath all of that, right?
Listen, Gyi's been at this for 2 decades? I'm at a decade and a half. I feel like him, along with others, have tried to preach this, scream it from the rooftops about how important it is before you engage with the marketing agency is to just understand what the terms of service are. If you're going to be given access to specific platforms, what is the reporting going to look like? How are we defining success? A lot of this is missed. And then, unfortunately, it becomes too late when you're at the end of a potential agreement, or maybe the relationship has soured. You've thought for 3 or 4 years, you've owned everything, your website, your content, access to information into some of these tools. And then when it's time to untether, you realize you're in a position where you have to essentially start from scratch, right? There's a lot of proprietary tools and systems out there, and they don't know what they don't know. And that's what we're out here trying to do, is just spread the good word, highlight some of the offenses, and ensure that firms are put in a better position to protect themselves.
We're going to get heated today, y'all. So this conversation, Ron, you are entirely to blame. I'm just going to lay this at your feet. So all liability heads in the direction of Ron Latz. That's been officially stated, noted. So this, you shared on LinkedIn something that you said, true story and a riddle. And it was about an issue regarding some LSAs. Now, we're not going to reveal names on all this. I know Gyi wants us to just name drop here, right?
No. No, offenders. We don't name the offenders.
Exactly.
We just name the offenses.
That's right. So we're setting up our proprietary marketing company. Gargoyle Marketing is our offender here. And so Gargoyle Marketing is solely responsible for all offenses that are being discussed during this episode. So Gargoyle Marketing is helping law firms run LSAs, but there are questions about where did money go? So Ron, if you want to talk a little bit about this, you need to look at your contract issue or dealing with some of those. Take it away.
Okay. I'm just going to give a very brief overview of what the post was essentially about to set the stage, and then we can go from there. But Gargoyle essentially engaged with a law firm that was allocating $750 a week or $3,000 a month towards their LSAs. And the terms, the billing model is there is again, we can get into flat fee versus percentage of spend, but the entire crux of the engagement is that if there is any unused dollars, unspent dollars in LSA, which happens pretty frequently depending upon your practice area, that those unused funds are then rolled over into the next month. And hopefully they're completely exhausted. Now, what was happening over the course of 6 months is that there was difficulty exhausting the budget. They were not spending, right? And
that sounded so euphemistic somehow.
Yes. Something was awry, and we tried to dig into it. And unfortunately, the firm had relinquished access to the primary Google LSA interface, so they couldn't use Google's tool. Instead, they were given a proprietary interface in which they would go in. This is a whole other problem, because then you're not marking leads as booked and rating them, and also
no wonder it wasn't spending.
Yeah, right. You're not creating the feedback loop. Anyway, we come to find after 6 months, there was one rollover over that entire month. They just said, this is enough. We're going to bring this all in-house. And when that happens, they actually are able to relinquish control again and have administrative access into that system. And when you log into it, there are some restrictions on how far you can go back to get the historical data from LSA. Like, you're not going to pull 2 or 3 years behind you. But either way, we saw that the spend did not match what they had agreed to in their contract with Gargoyle. And over 6 months on average, that account was spending about $1,000 per month. So if we take $2,000 of unspent dollars over the course of 6 months, roughly $12,000, that's a pretty decent chunk of change that could be reinvested, reallocated, put into another channel. And now the firm is in a position in which they need to go back. There was, as I alluded to in the post, there was one credit over or rollover over the course of that 6 month period. Mm-hmm. But it's just a lesson that continues to rear its head, where firms, they get excited. There's this honeymoon phase. They don't read the T's and C's. They're like, I just want it to work. And then they put themselves in a situation where, they were essentially price gouged there. And that's not ideal for anyone. And it gives a lot of people just a bad name in the industry.
Okay. So I'm to ask a maybe inflammatory question. How much of this do you think is predatory versus accidental omission? And not necessarily this specific circumstance, but when you have a company like Gargoyle, where does that fall between predatory versus oopsie?
Listen, Gyi, you want to jump in there?
Well, Charley, I'm glad you generalized it, because, in this specific instance, I have no idea.
Right.
But I will tell you this, as Ron dated me here, I've been doing this far too long. And I will tell you that this goes back to, there are some other Gargoyle-like companies that I could not, we're not naming any names.
Correct.
But this is a standard practice where it's a flat fee. And what they used to do was they would say, look, you pay us, you pay me, Gargoyle, we'll manage your media. You'll have no transparency into how we're spending your money, which, by the way, is a violation of Google's working with third-party guidelines. Like, even Google tells you you're supposed to separate fee from spend, which I think is something for us to talk to. And again, getting into like how do we protect ourselves against this conversation. But this is extremely common. It's very, very common for people to say, hey, look, give me some money. I'm going to go spend it for you. And then what the old-fashioned way of doing this was, and it was like the squeaky wheel gets the grease. So you'd call the advertiser, the law firm would call up Gargoyle and say, hey, the phone's not ringing. Gargoyle would be like, oh, let me look at your account and see what's going on. Oh, okay. And they would turn up the spend, and then the phone would start ringing, and then the firm would go away again, and they would turn the spend back down. And so, and to the point on Ron's post, my thing about it is because Ron tongue-in-cheek argued, like, what are we going to do about this? Number one, where this is going is this is just increased margin for Gargoyle. That's where it's going. They're just taking the fee. It's not, and when we talk about like trying to be generous and a judicious observer of these circumstances, Gargoyle can see very well that they're getting paid their monthly fee, and then they're if they're doing anything at all, looking at the LSAs even on a monthly or quarterly basis, they can see the spend number doesn't line up, and so. I'll give you an oopsie on a month. I'll give you an oopsie on maybe even a couple months if I'm in a really good mood and I've had a lot of coffee. But for years, come on now. Come on.
Okay. They know. And I don't think that there was malicious intent, Charley. I think they have an opportunity to make things right. Mm-hmm. And I think that working with them and facilitating what will now be an offboarding process, because that trust was completely lost. But that's like a whole other dovetail into this conversation. They found themselves leveraging a proprietary CMS.
Yeah.
They thought that they owned it all. They thought that they had everything. And now when they're looking down a proposal sheet to redevelop and then refresh or redesign their website, there's just a lot of additional costs that are associated with rebuilding that maybe they, most firms aren't expecting if they're going from, a WordPress to a WordPress instance, for example.
So that's I think we should call that out for folks. That's an additional huge issue, is this idea of proprietary platforms versus open source platforms. And again, I'm very much like this. You got a limited budget. You don't have a lot of, even though I could argue that you could find freelancers to probably build WordPress. And, usually my response is, if you really want to twist my arm, like, just use WordPress. But do I have some empathy for people who are like, look, I want a basic website builder. I'm going to hop on Squarespace or something. Mm-hmm. If you're going to do that, recognize what Ron is saying, that even if you save on the build and the development and the front end using a proprietary block building type of interface like a Squarespace, on the other side, let's say you do a great job and all of a sudden, like, your site's cranking along and you're like, oh, I need to actually scale and add functionality and all this stuff that Squarespace doesn't do, be prepared to rebuild your website from the ground up, because you can't take that technology with you. You are paying the fee to the proprietary platform as long as you are using that system. And my other issue with it, it's even worse than that, because sometimes if you look at some of these agreements, these gargoyle agreements, it's not just the technology, it's the content itself that you're licensing from them.
Yep. That's terrifying. I mean, honestly, that's the thing that I've looked at a lot of contracts. It's one of the things I do for coaching clients is they'll send over contracts and have questions about, hey, do you know what this fee actually means? Do you know what this phrase really means? And I have seen some of these ownership issues pop up where it is almost disputed, where who really owns what in this process. And for someone who's building on, I mean, look, it's probably known that I am friends with a company that has a proprietary platform that has websites on it. And my point of judgment is, how easy is it ultimately to migrate, and how restrictive will they make that process? How combative will they make that process for you? Because if it is combative, that infuriates me. And it has caused rifts in relationships in the past with other companies where I've said, I can't recommend such and such company, because it's not because they won't do a good job while you're there. It's what happens if you need to go somewhere else because you had an unhappy experience. You have it was an oopsie, but it lasted for 4 months and that trust is broken and you do need to go somewhere else.
We call that the Hotel California problem. You can sign up anytime you want. You can just never leave.
That's right. Yeah, I like that. Okay. I'm gonna rob that from you, Gyi.
It's yours.
The Hotel California problem. And then related to that, the ownership issue. So proprietary CMS systems, we own your content. Why does that keep slipping by? Like, why does that keep happening?
I wish I knew.
Right?
I feel like I can repost that post every single week. People still won't read it, or they will just say, "Oh, whoops," or they're buying for price, or they're buying, like, it's. I don't know. At this point, I don't think it's not enough to say I don't know what I don't know, because this has been around for quite some time.
Just for our own therapy here, let's go through all the things that law firms should retain ownership of.
Great.
Here are the ones, at least from, and I'm going to focus on digital marketing. If you guys got a couple maybe that are outside of that context, you can throw those on too. But number one, and I see this. In fact, there was another big box gargoyle company who was registering domains on behalf of their clients and being like, we own your domain. So domain registration, number one, you have to own your website.
Agreed. Oh my gosh. You could own your house, but it turns out you don't actually own the property it's on. Right. That's what it feels like.
Yeah. Or like, you don't have the title or something. Like, you got the mortgage, but not the title.
You're just a guest in your own living quarters.
Number two is Google business profiles. So we see this one all the time. Same thing as registering your domain, but if somebody else is listed as the owner, they've got full, they can shut you out of your own Google business profile. And if it's not intuitive and obvious to folks listening, that's your primary real estate on brand queries. That's where all of your reviews are going to be. That's where you're going to have the most visibility for searches on your name and your firm name and all those non-brand local pack queries, yada, yada, yada. The third one that I say is Google Ads, the Google Ads accounts. And I know that one is a little bit controversial.
Mm-hmm.
But my attitude is that even so, a lot of the gargoyle companies will say, look, you got to use our accounts because we've got data and we've got account history and all this stuff. And that's true. That's factually true. The problem is it's back to the Squarespace problem. You're renting that from them and you're not building equity in your own account. And that's the part that lawyers misses, is that your data has value. Your accounts have equity as you build them up and spend money over time. And if you're renting that, you're passing that on. And again, I would say, look, if you're a law firm that's like, I'm just getting started and I'm not, I have no plan to grow into bringing this kind of stuff in-house or managing it or working with agencies. Like I want the Squarespace version of this and I just want some leads and the phone to ring. I'm like, you know what? As a starting point, maybe that's right for you, but you're paying a huge premium for that because you're not on the title. This isn't your stuff. You're renting this stuff from them. And the last one that I'll throw in there, and then I'll let you guys go, is Google Analytics. This is another one where it's like everybody else you see, and then these agencies or gargoyles will say, well, we can't give you access to it because we put it in our agency account, and so we'd be giving you all of our clients access. And I'm like, that's your problem, friend. Like, what do you want me to tell you? This is your data. And so it should be very clear in your agreement that you own those things and that the gargoyles, everything they do on your behalf, that's work product of yours. It's your stuff. All right. End of rant.
Let me jump on the Google Ads one too, because there are pros and cons to both of the approaches. I just think that they need to do a better job outlining exactly what you're going to get and what you're going to lose if and when you untether it. There could be a perfect example in which they want the Squarespace setup. They just want to rent it. They're going to take advantage of the economies at scale and the statistical significance of all the data that agency has collected. Great. Now your unit economics are going to look better, right? Your cost per clicks might be a little bit lower. Take advantage of that. That is a benefit. Those agencies, they sell on that type of advantage.
Mm-hmm.
But when you leave, here's what you need to expect. You are going to see an increase in costs. You are going to see a decline in qualified opportunities and retained clients, right? There are things that are the downstream ripple effect is going to impact your business if and when you leave. If not, if you say, hey, I'm still going to go that way, I'm going to find another agency that controls it all within their agency account. And that's how I'm going to operate. To each their own, by all means. But you got to know before going into it what's going to happen if you want to remove yourself from that relationship.
Ron, that's why I love your viewpoint on so much of this stuff, because that's the whole point. It's informed consent, right? You have, as a business owner, you've got to make a lot of these decisions, but people need to be informing people so that they can actually make an informed decision. Because again, the SEO companies, the PPC companies out there, there's no pressure on them to tell you this stuff. And so it's whether you want to call it whoopsies or willful misleading people,
walking right up to that line.
Yeah, straight up. And I'm gonna drop in here, and Charlie, you can drop these in the show notes if you want, but I'm dropping the Google Ads and the Google Business Profile documentation on working with third parties. I mean, so much of this stuff is spelled out right there. It's like you just run your contract through this checklist, you'll get 80% of the way there. Because again, transparency about fees, ownership of accounts, it's all right there. I mean, Google's telling you this stuff. And again, Google has, this is their thing too that I get so frustrated about. Some of these gargoyle companies, they're Google Premier Partner companies that aren't following Google's own guidelines. And so it's like Google's like taking these guys out to Mountain View and buying them dinner and showing them all this fancy new stuff and opting them into beta programs. And I'm like, they're taking advantage of the advertisers because again, it's the same problem. Google doesn't, I mean, really, deep down, Google doesn't really care, right? Like Google cares about getting paid. And so anyway, there's a huge conflict of interest there between the ad platforms, the people managing the ads, and then the advertisers themselves.
Yeah, I mean, look, that whole idea of informed consent, that's right on the nose with it. you guys know I entered the agency game just a couple of weeks ago with, as we're recording this, with an email newsletter agency for law firms. And one of the things that Jenny, my business partner, and I agreed on at the beginning was the law firm that we're working with has to have full ownership of their email service provider. It is their list. It is their technology. The templates that we build are theirs to take with them should they take it. The content is theirs to do with what they will after it has been published, because everything that I've seen in the coaching space that drives me up a wall, including folks who have felt hostage to digital marketers. And sometimes it's as simple as, I'm afraid of leaving because I have so much information from my Google Analytics and it just seems like they're not going to play ball. Or they've heard these horror stories, some of which are 12, 15, 17 years old now, of I've heard that this such and such company will link bomb my website if I leave. Like, there are suspected direct malicious practices. I have a hard time verifying them directly, but it feels like, how are all these rumors happening if there isn't something happening?
I will verify them directly to you that it's still going on right now. We just saw an example of a gargoyle style company that is intentionally putting no index tags on sites. Another gargoyle company is seemingly intentionally, they would say they're reverting the site back to the condition it was when they took it on. So they're undoing all the work that they've done over the years, which again, it's like, I mean,
I just had an agency go in without the approval or proper DBA documentation, go in and keyword stuff a GBP name in a market for a firm just to jack up local rankings.
That's a toughie to get suspended.
They didn't. They didn't get suspended, but I joined the call and I said, "Hey, this is great, guys. We got the new firm name. Love it." And they looked at me. And I was like, "Well, was anybody aware of the change that got made on Google Business Profile?"
No.
And then they just have to go back. They had to request. The agency knows what it's doing there. I'm sorry. They know exactly what they are doing there. And in order to make the reports go like this, they had to do something. Listen, it's competitive market, competitive practice area. They didn't have as many reviews as others. They were trying to find the competitive advantage. All right, talk to the firm. Just make the recommendation. I bet if you lay out your case as to why we should be doing this, they're going to go and get the DBA. It's just like the cloak and daggers, the smoke and mirrors. I don't understand. But same thing. You talk about. Go ahead, Gyi.
I was going to say, there's two other. I didn't want to. I was going to jump topics because we're in this. You got me thinking about all these things on contracts that come up.
Yeah.
Another one that I think about, and again, there are different reasons to enter into different length contracts. But if you don't, and Ron said this at the start, this is really, to me, beyond like the really truly unscrupulous folks. You got to get into the defining what success looks like, and then that should be a part of your agreement. You know, if you're, I'll give you an easy one. If someone's setting expectations with you that you're going to get, ROI from SEO in 3 months.
Hear that, Conrad?
but you're in a 3-year agreement. Well, hold on. What happens in month 3 when you don't get ROI? You're stuck. And so your contract length needs to be tied to, in my view, some kind of objective metrics. And so, if you're like, hey, look, I'm willing to do a 12-month, but over the course of 12 months, here's what I should expect from leading indicators of success and then ultimately business metrics over that period of time. And again, my view of it, and this is just my view, so I know there's a lot of different ways to do this, but we're month to month. If you're not happy, then we're not doing our job explaining what we're doing on your behalf. We're not communicating. I always tell my team, I'm like, are we communicating the value of what we do? Starting in month 1. And guess what? In most of these instances, month 1 is not conversations about return on investment because it's law firms, people. You think you're getting a return on investment from an ad click in 30 days?
Yeah.
I mean, have you run a law firm before? That's not how fast these cases go most of the time. So
Yeah.
I don't know. There's some ads out there. I don't even know if I need an attorney for my accident case, Gyi.
Well, that's going to be our next time we come back. That's what we're going to be talking about is AI, fully AI, automated AI law and marketing, right? It's going to be everybody's bots tied. It's dead internet.
Oh yeah. Oh, we just depressed Ron real fast.
Yeah. I felt like I was making a fool of myself with that stuff. Because then people think that I'm engaging with the bot. And then they hit me up and they say, that's not a real person. I'm like, the sarcasm is just getting missed here. So I'm going to stop doing this to myself. And now I just ignore it. But, spend a lot of time investing in content and sharing and posting it every single day to have, individuals that go in and try to sell within the comments and promote whatever it is that they're attempting to sell. Comes frustrating.
So that makes me think of something specific here. So the whole bots system there, how much do agencies potentially utilize bots, purchase traffic, artificial interactions to boost their own results? Does that happen?
Yes. So there's a couple layers here.
I'm going to end up so depressed by the end of this.
well, this is my view of this, and I know the three of us have talked about this online, and I look at it this way. I'm like, look, if a bot can do something better than the person can do, if you want to survive the future, you better find a way for your business to execute and deploy that technology to do that thing. And so in the context of ads, media purchasing, in the context of content creation, in the context of a bunch of other marketing activities, there's all sorts of stuff that the bots can do really, really well. On the other hand, you alluded to click farms there, which is click-through rate manipulation. So people that are uninitiated, we'll post some pictures online, but there are literally warehouses all over the world of devices that are just creating fake clicks to trick the engagement engines into rewarding those profiles that are getting the clicks. That's a thing. Now, I don't recommend you do that because, and really, I don't. This is my whole thing about tricking the algorithms altogether is the algorithms are learning, folks. So you might trick it today. Spam works until it doesn't, but the long-term liability is the bigger issue, right? So talk about the example that we're talking about right now. When you can tell that a bot published something and it's obvious that it's just a copy and paste job, you don't want to engage with it. In fact, some people, I think more and more people are going to be trying to curate their feeds to block that kind of content because you just don't want to see it. The interesting thing to me is twofold. One is that there's a lot of content that I'm sure that I'm engaging with that is bot, but I can't tell. And so it's is it no harm, no foul? I mean, I can't tell, right? Pass the Turing test, I can't tell. On the other hand, I get worried that I'm blocking people that are actually just really bad at writing content.
I agree. I have seen this.
I look at their comments. I asked them, and I've been wrong. There was someone that kept doing it on my posts, and I just responded back is this you? Because I can't tell. And they were insulted. And I just said, I'm sorry. I didn't mean to insult, but you're following the formula. It's the 2 or 3 sentences. It's the bullet. It's the arrow. It's the tagging me at the end of every single comment, right? But that's the conundrum we get into here because you post, and within 15 to 20 minutes, if you have 4 or 5 bot comments and then you don't respond to them, the algo thinks that you're not being responsive and reciprocating, commenting back. So it's you try to play the game, and now I just delete.
And I'm going to tell you something. The bot content, it goes viral. I mean, I've seen it happen time and time again because the bots know how to game the game. But again, is virality the long-term business objective? Because again, you might go viral. Did it get you the kind of attention you want, or did it get you attention saying, hey, these guys are just using this copy and paste job, and so I'm not going to engage with it because I know that even though it's getting all sorts of crazy impressions, and and then you couple that with an engagement pod and a couple other things, gets a lot of engagement, gets a lot of visibility, but did it really accomplish the objective of gaining attention for the affinity of like, oh, I like this person, I would recommend this person, I would hire this person. And again, I think the other thing that was brought up, because I'm a Justin Welsh fan. I've got the Justin Welsh system. I get the templates, but guess what? Change the words, people. Like I'm like the templates drop, and I'm like, here we go. Here come the Justin Welsh crowd, which I'm a member of. But change the words up a little bit, folks. And my other thing too, and this is another thing, and I'll drop this in there too, and then I'm ranting again, so I apologize. But Google puts all of these guidelines out about creating helpful content. So the short version of this: use the Justin Welsh scaffolding, but make it your own experience. Share your insight, share your experience, share your expertise. That's the way to use this stuff in a way that I think positions you as an expert, makes you the authentic you, and then it's helpful to have some structure and some bullets from some of these systems.
And by the way, as a universal rule on this show, there's no such thing as apologizing for a rant. This is a rant conditioned and rant welcoming.
Thank
show.
you. I feel included.
It's a safe space for you, Gyi.
Thank you.
Kind of related to that, but something that started popping into my mind as you were talking about that is attribution. And there might have been something Ron was talking about, coupling with what you were talking about, Gyi, where these days in the agency space, I think we all recognize that kind of like multi-point attribution for how a client is ultimately acquired. It feels like the days of true, solid in-point attribution are not dead. Like you can still attempt some of it, but it's almost like we need informed in-point attribution. And I know that a lot of law firm owners are having a harder time because they feel like it used to be, I could invest $5,000 a month in SEO and we could very quickly tell the organic results and how much we were adding from that. And now they feel like, okay, I'm doing that, but I also feel like I've got to be doing Google ads. I've got to be doing LSAs. I need to be doing some of the social media, and they're having a harder time with attribution. How are you all either communicating with clients or guiding your clients, Ron, on that issue?
Ron, go first.
Where to start here? Well, first off, if you're engaging with the law firm, new agency, you're defining success and identifying which metrics and what business goals are going to tie together in order to make sure at the end of the day, this is what we want to accomplish. That's number one. Number two, Gyi talks about this all the time. Get them to commit to separating branded and non-brand traffic. So you understand what's coming in from your community involvement, business development, and sales efforts versus your digital marketing efforts. The day of click, call, consult, retain outside of, some criminal instances, I think is mostly over because the client's journey is no longer linear. There are so many touch points, 8, 9, 10, 11, 12 plus touch points in which someone might engage with your content that you've got to understand at least, when I'm collecting this information, am I getting the qualitative data plus the quantitative data, right? The text sourced attribution plus like, where did you find out about us? Who told you about me? Where did you hear about us? So that you can compare both of those and don't pull those investments out prematurely, as well as double down on the things that are working, right? So like we talked about a lot of tools and systems. I'll just throw this in there and then pass it over to Gyi. Your call tracking software, whatever one you're using, I don't care which one it is, own it. If you don't own it, make sure that the agency is going to allow you to get into that tool in order to set up some of these integrations. Because when you're sometimes underneath the agency account, you don't have those permissions to do so. So you can't push that data into an intake management software or a CRM because you're restricted. So like make sure you're dotting those I's and crossing those T's, and then you can start running some of the reports.
Yeah, no, I'm totally aligned on that. And I'll give you a little bit, I don't know how long you wanted to go here, Charlie, but you can always fix it in post. But
no, there's no such thing as editing on this show, including me saying that there are no edits on this show. And we still have at least a solid 20-minute window on the calendar. So
okay,
go for it, Gyi.
So, I always take it back to the John Wanamaker riddle. I know half of my advertising is working. I just don't know what half. So that's what advertising was forever. Forever ago. People just throw money, big brands throw money at it. We don't really know, days of Don Draper and, dream a dream, and
La-la.
we'll look at revenue at the end of the year and see if marketing worked last year. And then digital came along, and the digital marketers, myself included, were like, hey, we solved Wanamaker's riddle. We can tell you exactly how people are finding you. And forever, this was last click direct response attribution. So as Ron alluded to, it's, someone does a search, they click an ad, they come to your landing page, whether they call you or whatever, you can track that whole journey, which is great. And it's true. And I will say this I think this is another kind of myth that I would like to dispel for everybody. Legal services consumers do not act like a monolithic being. People hire lawyers in all different ways, in all different contexts. And, and again, I think if I'm going to give someone a pro tip here, get on someone's radar before they even need your services, so they're thinking about you when you do. All that being said, there are some legal services consumers, and I'll give you a couple contexts. They don't have any lawyers in their family. They don't know any lawyers in their community. Maybe they're embarrassed about the thing that they're looking for a lawyer for, so they're not going to seek a referral from a friend or family member. So guess what they do? They do a search, they click, they call, and they hire. And that linear client journey is very trackable. And you can do your cost per client and your non-brand direct response cost per client analysis and return on ad spend analysis. And it's great. And you should do that. This is what I'm hearing right now, because we're starting to swing the pendulum back. So now the marketing people are telling me, oh, you can't track anything. And I'm like, no, that's not what we're saying. Track that stuff. But to Ron's point, segment it. And the big ones for me here are the segmentation. And this is another just like buzzwords, and goes back to marketing accountability and putting this in your contract and defining success. And I'll say there is some accountability on the law firm side on this one. Yeah. But the lawyers need to tell the people managing the media and the marketing messaging what's qualified and what's turning into clients. And so many times the law firm's like, well, I'm not telling you that. And I'm like, well, then that's fine. Then we're going to manage to some other metric, because you're not giving us the metric that actually matters. And so you have to have a connection. Your CRM data, and again, lawyers, if you even have a CRM, it's a whole other conversation. But whatever you're using to tell your media buyer, or to tell the more likely than not now the machines, hey, this is a qualified consultation. This turned into a client. Go find more users that fit this buyer persona. If you're not doing that, you're at a huge strategic disadvantage, and you should be having those conversations at the time of proposal and contract, because this goes to Ron's point about defining success. What happens is people like me, gargoyles, they'll just be like, look, I'm just going to give you top line traffic. I'm going to give you conversion pixel fires. I'm going to give you ranking reports. Yeah, right.
It sounds exotic and fun.
Yeah, exactly. It's exotic. It's fun. It sounds exciting. It sounds, it's provocative. But you can't pay your office lease with any of those things. You can't pay salaries with any of those things. And so if you're not segmenting brand versus non-brand, and Ron said this, and this is a huge one we see all the time. A lawyer will call me up and be like, hey, we're going to cut all of our offline. And I'm like, why? And they're like, well, we can't track any cases to it. I'm like, well, you're not even asking anybody how they found you. So how would you even know? Maybe all these people are coming in because they listened to your radio spot or saw your billboard for 100 years, all these things. And so it's so important. And I know, Charlie, you've been pushing this hard online, so I'm very grateful for it. But it's multi. And so you can create a system that follows your consumer's journey from the first time they engage with your brand all the way to the time they sign up and beyond. But you got to create the data infrastructure and the systems around actually measuring that and monitoring it. All right.
And that freaks them out. It's a lot. That's a lot to have to do. And so it almost loops back in itself, where you end up with some of these low-cost providers who recognize, as a low-cost provider, my only way for a long-term win is to lock you in with some stuff that you don't realize necessarily is going on, because you're none the wiser to it. And now, instead of you turning over to an agency that you can afford to scale up 2 years from now, you're going to hold out with me for 4 or 5 years because the pain of disconnect has become far too great for it. And my hope is people hear this message early enough in the journey. But all three of us know a lot of people are going to hear this message and they're in the journey. So if they're in the journey right now and they're experiencing the pain of disconnect, the feeling of I'm trapped, I feel like my agency is doing stuff, but that I believe is unethical, unfair, whatever it might be, what should they do in that moment? Ron, what do you recommend that they do?
I mean, one of the things, especially when it comes to like reporting, you can ask your agency to go. If a firm went to Gyi and said, hey, can you break out my branded from non-branded traffic so I can get a better understanding about how a certain campaign did, or if we put up a billboard in a specific market, right? There's ways that you can track that and at least collect some signals to know if it's working. That's something. Obviously, if you're coming up on renewal, you could start having those conversations with other agencies so that you could set the stage to have a partnership that might be a little bit more aligned, within your best interest. But it's hard once you're locked into that 3-year contract, right? Like I have had success with some of the gargoyle agencies in which we realized that the purchase that was made might have been impulse, shouldn't have done it. Let's have just a very respectful conversation about, hey, all the gargoyle wants to do is keep the monthly recurring revenue. So can we find a better product or vehicle or ad unit that we can put those dollars into? Because you don't want to keep shooting yourself in the foot or invest in poor first impressions at scale. Like, see what you can do within the parameters and then put yourself in a position when you're having those conversations with new agencies so that you're not in the same exact stance that you were with the other one.
Ron, that last part, that last bit of the sentence,
because it keeps happening,
barely made its way out of you. Like it just came out. It almost looked like there was just a puff of dust of just, I can't deal with this anymore.
Because it's, I know working within an agency, like getting the appropriate systems I've worked into situations where the firm cannot tell me there were 3 different emails that were used to create their GBP or their search console, and they don't have access to it. And then you talk to the agency, well, I don't know it's like, who was running the ship here? And that's frustrating because they want the data, and it prevents us or legal marketers from doing as effective of a job as we can because we're operating half blind.
Gyi, anything to add to that?
Yeah, I'm really letting my sympathy and empathy go forward here for these lawyers. I think step one is if you're in this, and even before you even realize there's a problem, it's you got to step back and being like, something doesn't feel right. My agency's slapping high fives every month. They're sending these reports. They're telling us that we rank for all these keywords. But if you're not picking up the phone, and let me tell you, having done this for a long time, people still want to talk on the phone. And so if your phone's not ringing with people who are saying, hey, I have this issue that I believe your firm helps me with. If that's not happening, I don't care what all of this other gobbledygook says. So that's your first instinct of and really it should be contextualized against what you're investing in. So it's look, I'm spending $100,000 a year and my phone rang twice last year. There's a problem here, folks. Step 2 is to pull out your agreement, because if you get to the point where you're like, I got to get out of this, even if you don't know exactly what's going on, the good news is a lot of these agreements, the gargoyle is breaching. And so it's just a matter of figuring out where gargoyle is breaching. And then you're coming to you negotiate your way out of it. And a lot of the private, this is one of the positives, I was talking about turning off social media before, but here's one of the positives of social media. There's a lot of private Facebook groups. There's a lot of folks, that are out there trying to do good work. Call Ron. There's a lot of Slack communities where people can share their experiences of how they've navigated getting out of some of these really draconian bad news contracts.
Yeah.
But at the end of the day, there has to be somebody at your firm, whether if you're a solo, it's got to be you. That's just welcome to solo life. Or you've got to delegate this to somebody at your firm, or you need to hire, an independent third party that can really go in and say, look, let's untangle this entire mess here. Here are the issues that we see. Who's got access to these accounts? But if you're in that kind of boat right now, like it can be a heavy lift for you. You know, you're trying to practice law, like going out trying to figure out like who's got Search Console verification and stuff. It's like it's tough.
Did someone get the text message with the 3-digit code? Who did that go to?
Right.
That two-factor, man.
But again, my big theme here is that transparency cures a lot of this stuff. Oh, you know, we own our accounts, we own our data, we own our content. Get access to all the things. You know, help make them walk you through it. Make them document. If you're gonna outsource the management of passwords and stuff, like make sure that that's documented in a way that they can't pull the plug on it, because I've seen that too, where it's like, well, I used to have access to this and they changed the password on me. And put that in the agreement. Like it should say right in the agreement, this is all our data. Client retains all data, accounts, work product done on client's behalf. Done.
Easy peasy. Lemon squeezy.
There you go.
Simple enough. We've solved all the problems. Everything's fixed now. We can all just go on with our days. That's right.
Your friends.
Yeah. Honestly, yeah, that's you know, share this with the community. This is one of those. This is the type of information. I understand some people hear like a clever marketing idea, like, oh, I want this to be mine in my market. Please, something like this. Please share it with. If you are talking in front of young lawyers and you have the opportunity to say, hey, when you go out into the world, if you start your own firm, you know, you're going to rent your office. You better own your website. Mm-hmm. Like these are things that you got to know ahead of time. It will be better for the entire profession because agencies will have to respond to this and recognize, oh, I'm being put out of business because of my draconian contract, or at the very least, they're taking a hit because of it. And it would be better for the entire community to establish that behavior now before we see the largest amount of non-lawyer money start coming into the market, the private equity, et cetera. Yeah. If we can start establishing those standards now, it will be better for the profession. It will be better for the clients as well, in my opinion, who are served by the profession, to have owners of firms who feel secure and stable in what they're doing overall and aren't losing sleep over these issues. Mm-hmm. Virtuous cycle.
If you're in law school right now and you're not learning this stuff, send this to your career services office and spread the word so we can say, Charlie, man, they did teach us this in law school. It was your podcast that taught us it.
There we go. Whole curriculum from it. I'm sure Ryan McKean is teaching it to his students.
I know
that'll be the one.
Yeah.
All right, real quick, gentlemen, I am going to ask you my traditional final quick question, but starting with you, Ron, if people are like, I need to connect with Ron, what's the best place for them to do that?
I would check myself out on LinkedIn or go to legalphoenix.com, where I share as much as I can. I don't know everything, but I promise to share whatever it is that I do know.
Awesome. And that's Phoenix, Phenix.
Yes, sir. If you spell it the right way, though, it'll still bring you to the right place.
Smart man. And Gyi, what about you?
Yes, I too would suggest you go engage with my AI bot on LinkedIn. Just kidding. It's all me. It's all me there, for better or worse.
Was that picture you?
It was a picture of me. Or you can hit me up at Attorney Sync, Attorney SYNC, or anywhere else. All you gotta do is just type my name into Google, and I'm the only one who comes up. So just learn how to spell my name.
That's right. Your parents were thinking ahead on that one, weren't they?
Right.
All right. Final question I'm going to ask each of you real quick. What are you reading, watching, and listening to these days? Gyi, I'm going to have you jump in first. Reading, watching, and listening to.
So I'm reading SPQR, Mary Beard's Rome book, and it's really good. I haven't watched anything great recently, but it's in my queue to watch White Lotus because I'm behind, and I liked the first 2 seasons, but I haven't watched.
3 is good.
I've heard it's good.
Yeah.
Heard it's good. And I'm a huge Walter Goggins fan, so I'm excited about that.
There you go.
And what am I listening to? Usually it's 90s, like, I guess it's been like 90s alternative rock right now, which is like weird for me, but it's sad. This is like, I'm really going to tell you who I am. It reminds me of my high school weight room. and I like get so pumped up, like more, I'm 46, so it's like hard to get the old machine going. But I hear some Alice in Chains come on, and I'm like, I got to get this rep out. I got to get this extra rep out. So that's what's going on with me.
There we go. I have Nirvana, whatever the Nirvana station is on any platform, just running all the time. Yeah. All right, Ron, how about you?
Right now, I'm reading a book called Onboarding Matters. It's by Donna Weber, just trying to improve that process. It's just really interesting. Typically, I'm looking at, legal marketing stuff and sales and branding and positioning. So it's kind of a break away from that. I don't watch a ton of television, but right now is the season in which I consume an obnoxious amount of television for the NHL playoffs. Although I do have a horse in the race, we are getting absolutely walloped.
Hey, at least you're there, man. At least you're there.
We're there. We're there. We added some injuries. I'm a Devils fan, so I've had season tickets in the past. It's so hard. It's hard. Carolina just has our numbers. Such a more physical team. Anyway. And what am I listening to? I'm listening to the Charley Man Tom Tona collab. I learned about hiring today.
Thank you.
Episode today. Yes, as I'm like, man, this onboarding and hiring, like it's good. It's really good. I like that. I like what you both have done here.
Huge fan of that.
You.
Yes, I've been sharing that everywhere I can. That's good stuff, Charlie.
Thank you. That's been fun. We're playing around with some of the podcast stuff, doing episodes like this as well that are just a break from format. But what we're trying to establish is that the break from format might be the new format.
It's
I'm
cool.
here for the variety show.
It's cool. I like it. I like it. And
Awesome.
Tom, New York guy, I hear his voice. I hear that voice every day when I'm walking the streets here. So
it just soothes you when you hear Tom Tony.
I'm a normal New Yorker.
Awesome. Gyi, Ron, thank you so much. I'm glad we made this happen. I'm really looking forward to hearing from folks who listen to this episode, because I know based on the discussions I have with firm owners, this is the type of stuff that they always wonder about, but they need to hear the people who are actually involved talking about it.
We'll have to do it again. We didn't even hit exclusivity or fee models, or we didn't hit any of that.
We got to save something. I
know.
I get the feeling we're going to do this again because it was easy and fun and informative, and that checks a few boxes for this show.
For sure.
All right, gentlemen, thank you very much, and we will see you all in the next episode of They Don't Teach This in Law School.